Hi, welcome to another episode from our GDPR IQ Thought Leadership series. Here we'll be discussing how the CCPA will force significant changes on companies not caught by the GDPR in North America. The dust from GDPR's May 25, 2018 date has not settled, and the data protection community is now bracing itself for the new California Consumer Privacy Act, or CCPA. Several states in the U.S. are following the General Data Protection Regulation, or GDPR, with similar privacy initiatives. On the 28th of June, 2018, California passed a sweeping consumer privacy law, CCPA, a landmark policy constituting the most stringent data protection regime in the United States. The CCPA is likely to force significant changes on companies not caught by the GDPR, and many businesses must prepare to scramble to comply. If you've worked hard to comply with GDPR, you now have additional work to prepare for the CCPA implementation in 2020. As of January 1, 2020, Californians will enjoy a higher level of data protection, as EU citizens do under the GDPR. The core of the CCPA consists of 5 new rights awarded to Californians. A right to know what personal information is being collected about them. A right to know whether their personal information is sold or disclosed and to whom. A right to say no to the sale of personal information. A right to access their personal information, and a right to equal service and price, even if they exercise their privacy rights. The CCPA also contains less obvious rights embedded in the legislation, such as the right to data portability, and the right for consumers to benefit from the sale or disclosure of their data to third parties, or incentives. Organizations anywhere in the world that process the personal data of California residents will be bound by the new regulation if they, or their parent company or a subsidiary, meet just one of the following thresholds. Generate gross revenue above $25 million. Gather personal information from more than 50,000 California residents, households, or devices annually. Receive at least 50% of their annual revenue from selling the personal information of California residents. A July 2018 TrustArc survey of executives, legal, and IT personnel of companies with 500 or more staff found that just 20% of U.S. companies are GDPR compliant. The major challenge cited is the complexity of the legislation and the lack of access to third-party expertise to facilitate a GDPR compliance program. Clearly, the new level of complexity generated by the GDPR, CCPA, and emerging laws require a privacy methodology to manage data from multiple channels and devices. Your business at large, and roles such as the marketer, must be able to maneuver through the maze of consumer consent preferences and data requests. As a first step, you should learn about the new law and work with a professional data privacy third party such as FileOM to interpret the new rules and monitor any changes. Then commence the following. Prepare data maps, inventories, and other records pertaining to the personal information of California residents, households, and devices. Consider alternative business models, including California-only sites and offerings. Establish designated methods for submitting data access requests. Provide a clear and conspicuous "Do not sell my personal information" link on your website's homepage. Fund and implement new systems and processes to verify the identity and authorization of people who request data access, deletion, or portability. Update privacy policies with newly required information, including a description of California residents' rights. Establish policies to avoid charges that your business willfully disregards the California resident's age, by implementing methods of obtaining parental and guardian consent for minors under 13 and direct consent of minors between 13 and 16. Privacy legislation will always be subject to change, no matter where an organization is located and in how many countries it operates in. FileOM recommends an accountability approach to comply with multiple laws, GDPR and CCPA, for organizations operating across jurisdictions. Our approach to implementing privacy management policies and procedures is to help organizations meet multiple laws at the same time. Take advantage of a free 30-minute GDPR assessment for your business. Discuss the state of your compliance with a qualified practitioner and learn what you need to do to become compliant.